All U.S. prisons are debtors' prisons. Issuing bonds for profit on prisoners has finally been deciphered. Why do we have a rise in prosecution for nonviolent crimes? As soon as your Social Security number hits the system, someone is buying a bond in your name that accrues interest the longer you sit in jail. The courts are operating under statute law. A statute is defined in Black's Law Dictionary, 4th edition revised as a kind of bond or obligation of record, being an abbreviation for statute merchant or statute staple. Statute merchant is defined as a security for a debt acknowledged to be due, entered into before the chief magistrate of some trading town, pursuant to the statute 13 Edward I de Mercatoribus, by which not only the body of the debtor might be imprisoned, and his goods seized in satisfaction of the debt, but also his lands might be delivered to the creditor till out of the rents and profits of them the debt be satisfied. The grand jury foreman is the drawer or maker of the indictment by his signature, the defendant/debtor or straw man is the drawee, and the state is the payee, while the live man or woman is the payer. What they are doing in the courtroom is all commercial and is in conformity to 27 CFR 72.11, where it says all crimes are commercial. What the judge and prosecutor are doing in the courtroom is making a commercial presentment under Section 3 to 500(1)(1). Unless excused, Section 3 to 511, presentment is necessary to charge secondary parties as follows. A. Presentment for acceptance is necessary to charge the drawer and endorsers of a draft where the draft so provides, or is payable elsewhere than at the residence or place of business of the drawee, or its date of payment depends upon such presentment. The holder may at his option present for acceptance any other draft payable at a stated date. B. Presentment for payment is necessary to charge any endorser. C. In the case of any drawer, the acceptor of a draft payable at a bank or the maker of a note payable at a bank, presentment for payment is necessary, but failure to make presentment discharges such drawer, acceptor, or maker only as stated in Section 3 to 502, 1b. If you don't accept the charge or presentment, you are in dishonor for no acceptance under 3 to 505 of the UCC, C, and 3 to 501, 2, A, B. Acceptance is the drawer's signed engagement to honor the draft as presented. It must be written on the draft and may consist of his signature alone. It becomes operative when completed by delivery or notification, 3 to 410 of the UCC. You are the fiduciary trustee of the straw man, which is a SESTK United States Trust. In this capacity, you have the responsibility to discharge all his debts by operation of law. You are also the principal or asset holder on the private side of the accounting ledger. You are holding the exemption necessary to discharge the debt. When they monetize debt, they have to have a principal, capital, and interest, which is what circulates as principal and is called revenue or revenue. Principal is where venue lies. When you are in dishonor, they cannot use your exemption to pass the debt or charge through your account to obtain a discharge, so they sell your dishonor, which has a commercial value of $1 million for each count. When the Social Security number is assigned or a blank bond is issued, and when you are imprisoned, the bond is filled out. This bond is called a bid bond, Standard Form 24, Rev 10 to 98, prescribed by GSA FAR, 48 CFR, Section 53.228a. This is also called a prison bond. These are also referred to as contract surety bonds. The first, the bid bond, provides financial assurance that the bid has been submitted in good faith and that the contractor intends to enter into the contract at the price bid and provide the required performance and payment bonds. The second, the performance bond, protects the obligee from financial loss should the contractor fail to perform the contract in accordance with the terms and conditions of the contract documents. The third kind of contract bond is the payment bond, which guarantees that the contractor will pay certain subcontractor, labor, and material bills associated with the project. On April 9, 2002, at 12:18 p.m., Lehman Brothers banking cartel in New York City agreed to provide prison industry leader CCA, Corrections Corporation of America, with a new $695 million senior secured credit facility, to be combined with a $150 million notes offering. The war on terrorism has created a buzz in the private prison industry. Less than 3 weeks after September 11, a New York Post story on the for-profit private prison industry stated, America's new wall of homeland security is creating a big demand for cells to hold suspects and illegal aliens who might be rounded up. In order to prosper, prison operators need to maintain a steady flow of prisoners and prison dollars. The Corrections Corporation of America owns most of your prison systems and sells its stock and shares on the New York Stock Exchange. The major stockholder is the Paine-Webber Group. There is also a Prison Realty Trust, PZN, which is a real estate investment trust, right, and is the world's largest private sector owner and developer. Prisons are nothing but warehouses for the storage of goods and chattel under commercial law. The warden is a bailee or warehouseman. The bailer is one who provides bail as a surety for a criminal defendant's release. When your dishonor is sold within the United States, it has a 6-digit accounting number and is called a cardinal number. When it is sold at the international level, it goes ordnance or military and uses a 9-digit accounting number. This is where AutoTrace and CUSIP come in. AutoTrace is the automated forensic traces investigation system and was designed in the Russian Federal Center of Forensic Science using a graphical toolkit developed at Automation Designs and Solutions Incorporated. Why is privatizing prisons so appealing to federal, state, and local governments? As The Nation put it, the selling point was simple: private companies could build and run prisons cheaper than the governments. Unfettered American capitalism would produce a better feder, saving cash-strapped states millions of dollars each year while simultaneously generating huge profits. The Nation explains this miracle would be accomplished: private prisons receive a guaranteed, per diem, fee for each prisoner, regardless of the actual costs. Each dime they don't spend on food or medical care, for prisoners, or on wages and training for the guards is a dime they can pocket. I have a pointed question for you: why aren't we, as principals on the private side of the accounting cycle, using our exemption priority to discharge all this public debt under the Uniform Exemption Act Section 3? Exempt means protected, and exemption means protection, from subjection to a judicial lien, process, or proceeding to collect a debt. The answer is we are all double-minded and do not know who we are in a commercial setting. Every individual in prison is in there because of commercial dishonor. This is why we now have a full-scale tornado of new statutes and codes such as the Patriot Act, for patriots, and the etc., for the U.S. citizen chattel slaves to conform to. But it's not that easy anymore, for you see, everything on the U.S. plantation is going to be illegal. This is being done to pay back the international bankers who are the executors of the U.S. corporation's bankruptcy. This information is for educational purposes only. This is not legal or financial advice. We offer this information as it is presented to us, we neither endorse or discredit it. Make your own decision regarding the content. For additional resources or questions, subscribe to this YouTube channel.